I'd like to start off with a bit of an explanation for my short hiatus. A very close family member died in the middle of the summer, and just in addition to grief, it's taken a lot of time and energy to make sure that the rest of the family was taken care of. Hopefully, we're back to a more regular tempo of releasing videos every few weeks. On September 9, 2024, the Federal Court of Appeal did something very interesting. A unanimous 3-judge panel fully reversed the factual conclusions of the court below to conclude that Facebook had in fact violated the Personal Information Protection and Electronic Documents Act in connection with the Cambridge Analytica scandal. And then rather than sending it back to the federal court to be determined by another judge, they reached their own conclusions and invited submissions on remedy. Hi, my name is David Fraser. I'm a privacy, internet, and technology lawyer with the Canadian law firm McGuinness Cooper. I also teach internet and media law at the Schulich School of Law at Dalhousie University. I should note that in my practice, I represent companies dealing with the Privacy Commissioner, including investigations and litigation like this. It's not common for an appeals court to reverse factual findings like that to begin with. They can only do so if they find a palpable and overriding error for questions of fact or mixed fact and law, and it's pretty clear that the appeals court found that. The earlier decision rendered in April 2023 was, I thought, pretty embarrassing to the Privacy Commissioner. You may recall for 2019 when the Privacy Commissioner of Canada and the Information Privacy Commissioner of British Columbia released together, with as much fanfare as possible, the results of their joint investigation into Facebook related to the Cambridge Analytica incident. Now, that incident took place around 2013 to 2015, so about 10 years ago. Both of the commissioners concluded at that time that Facebook had violated the federal and the British Columbia privacy laws, principally related to transparency and consent. Because Facebook did not accept that finding, the Privacy Commissioner of Canada commenced an application in the federal court to have the court make the same determination and issue a whole range of orders against the social media company. The hearing of that application took place in March 2023, and a decision was released from the federal court just over a month later. It concluded that the Privacy Commissioner did not prove to the court's satisfaction that Facebook violated our federal privacy law in connection with the Cambridge Analytica incident. And just a little bit of additional procedural information. Under our current privacy law, the Privacy Commissioner of Canada does not have the ability to issue any orders or to levy any penalties. What can happen after the Commissioner has released his report of findings is that the complainant or the Commissioner, with the complainant's okay, can commence an application in the Federal Court of Canada. This is what is called a de novo proceeding. The finding from the Privacy Commissioner below can be considered as part of the record, but it's not a decision being appealed from. Instead, the applicant, in this case, the Privacy Commissioner of Canada, has the burden of proof of proving to a legal standard that the respondent, Facebook, has violated the federal privacy legislation. This has to be done with evidence, which is where the trial judge concluded that the Privacy Commissioner of Canada fell significantly short, at least in the Facebook case. I did a video on that decision, and I'll link to it below. To understand this decision, we have to understand what it's all about. It has to be remembered that the events being investigated took place almost 10 years ago, and the Facebook platform is substantially different now compared to what it looked like then. If you were a Facebook user at the time, you probably remember there were a whole bunch of apps running on the platform. You probably were annoyed by friends who were playing Farmville and sending you invitations and updates. Well, those don't exist anymore. Facebook is no longer really a platform on which third-party apps will run. At the time, users could install apps and the app developers could get access to that user's personal information. Those apps could also get access to some information related to the friends of the installing user. The installing user had some knowledge and control, but the person's friends were largely ignorant of that fact and had no control over that. In a nutshell, at the time, one of the app developers that used the Facebook platform was a researcher later associated with a company called Cambridge Analytica. They had an app running on the platform called This Is Your Digital Life, and it operated for some time in violation of Facebook terms of use for app developers, hoovering up significant amounts of personal information and then selling and or using that information for, among other things, profiling and advertising targeting. The questions put to the Federal Court of Appeal was whether the judge below had made a reviewable error when he concluded there was not sufficient evidence put before the court to prove that Facebook did not get adequate consent from users, and whether they had failed to safeguard user data. The Court of Appeal concluded that there was sufficient evidence to reach these conclusions, and the judge below made an error in not seeing that evidence as sufficient. At the federal court level, the judge said that the Privacy Commissioner had failed to bring sufficient evidence to prove that Facebook did not get adequate user consent for the collection, use, and disclosure of their personal information and that of their friends. The judge below said it would have been helpful to have expert evidence on users' expectations and what Facebook could have done differently. The Federal Court of Appeal essentially said that's asking the wrong question, based on a premise that the standard of consent is subjective. PIPEDA uses the term reasonable in a number of places. The Federal Court of Appeal said that the standard for consent in PIPEDA is an objective standard and does not require that sort of evidence. On a daily basis, courts deal with determining what is reasonable in a whole range of cases without that specialized evidence. Judges can apply common sense. The court described the reasonable person at paragraph 63, saying, quote, "The reasonable person is a fictional person. They do not exist as a matter of fact. The reasonable person is a construct of the judicial mind representing an objective standard, not the subjective standard. Accordingly, a court cannot arbitrarily ascribe the status of reasonable person on one or two individuals who testify as to their particular subjective perspective on the question. As Justice Evans wrote, quote, determining the characteristics of the reasonable person presents difficulties in a situation where reasonable people may view a matter differently, depending in part on their perspective. However, the view of the reasonable person in legal tests represents a normative standard constructed by the courts, not an actuality that can be empirically verified." The Court of Appeals said at paragraph 60 of the decision, quote, "Subjective evidence does not play a role in an analysis focused on the perspective of the reasonable person. The meaningful consent clauses of PIPEDA, along with PIPEDA's purpose, pivot on the perspective of the reasonable person. Section 6.1 of PIPEDA protects an organization's collection, use, or disclosure of personal information only to the extent that a reasonable person would consider appropriate in the circumstances. Clause 3.2 of PIPEDA asks whether an individual could have, quote, reasonably understood, unquote, how their information would be used or disclosed. They then refer to also Section 3 and Clause 4.3.5 of PIPEDA. The Court of Appeal then said at paragraph 70, quote, "It was the responsibility of the court to define an objective, reasonable expectation of meaningful consent. To decline to do so in the absence of subjective and expert evidence was an error." Now, I think the Court of Appeal is both right and wrong here. There are times in PIPEDA where a clearly objective standard is created. Look at Section 5, Sub 3, which refers to the mythical, legal, reasonable person. It says, "An organization may collect, use, or disclose personal information only for purposes that a reasonable person would consider are appropriate in the circumstances." We are clearly looking at the reasonable person, i.e. the judge, applying this legal fiction. But in other places in PIPEDA, we're talking about conclusions about the person who is being asked to give consent to the collection, use, and disclosure of their personal information. So Section 6.1 deals with valid consent. For the purposes of Clause 4.3 of Schedule 1, the consent of an individual is only valid if it is reasonable to expect that an individual to whom the organization's activities are directed would understand the nature, purpose, and consequences of the collection, use, or disclosure of the personal information to which they are consenting. So it is reasonable, objective standard, to expect that the individual at issue understands. That's an objective assessment of a subjective situation. Now, in the consent principle, reasonable is used a few times. 4.3.2 includes, "The principle requires knowledge and consent. The organization shall make a reasonable effort to ensure that the individual is advised of the purposes for which the information will be used. To make the consent meaningful, the purposes must be stated in such a manner that the individual can reasonably understand how the information will be used or disclosed." Now, reasonable is used twice here. Was the effort reasonable? That's objective, but in light of the individual in question, which seems to me subjective. But then it says that the individual can reasonably understand, and that seems to suggest a reference to the individual at issue, who will always be subjective. A little further down, that seems to really apply a mixed objective-subjective assessment. So 4.3.5 in the consent principle says, in obtaining consent, the reasonable expectations of the individual are also relevant. You're looking at the reasonable expectations of that individual. It doesn't say the reasonable expectations of a reasonable person or the expectations of a reasonable person. So I think applied to this case, we're really talking about the reasonable expectations of a Facebook user in 2014, not a fictional creature like the man on the Clapham omnibus. The next conclusion of the Federal Court of Appeal was much, much easier to reach on the record before them. The Federal Court of Appeal very strongly determined that Facebook did not get adequate consent from friends of users who installed apps on the platform where those apps collected the personal information of those friends. When users installed apps, the app developer was required to inform the user about what personal information would be collected by the developer and how it would be used. At least in theory, that user could make an informed decision about whether to use the app, or maybe they can calibrate what data the app could access. However, if the app collected information about that user's friends, those friends were not given notice. They weren't given an opportunity to consent. And so on this point, the Federal Court of Appeals said, quote, "This distinction between users and friends of users is fundamental to the analysis under PIPEDA. The friends of users could not access the granular data permissions process on an app-by-app basis and could not know or understand the purpose for which their data would be used, as required by PIPEDA. The only conclusion open to the federal court on the evidence was that Facebook failed to obtain meaningful consent from friends of users to disclose their data and thus breach PIPEDA. This finding hinges mainly on Facebook's different consent practices for users of apps and those users' friends, and Facebook's user-facing data policies and practices with third-party apps more broadly. To the extent that this evidence was acknowledged by the federal court, it made a palpable and overriding error in its conclusion that there was no breach of PIPEDA. The court then says Facebook did not afford friends of users who downloaded third-party apps the opportunity to meaningfully consent to the disclosure of their data. Since friends of users were simply unable to review those apps' data policies prior to disclosure, this is not in accordance with PIPEDA. Clause 4.3.2 of PIPEDA requires that organizations make a reasonable effort to ensure that the individual is advised of the purposes for which their information will be used. The fact that users are informed via the privacy policy that this could happen was not sufficient in the court's view. Yeah, it seems very difficult to reach the conclusion that the friends had given knowledgeable, informed consent when they were not knowledgeable about the sharing of their personal information and were never given an opportunity to consent. The Federal Court of Appeal raised one of the big challenges of privacy in the modern online age. It says privacy policies are too long and nobody reads them. In a nutshell, long privacy policies are not the foundation of informed consent. On the question of whether Facebook fulfilled its obligations to safeguard users' personal information, the Court of Appeal found that Facebook failed to safeguard user data because it did not review the privacy practices of third-party app developers, and it did not act on red flags raised by apps like This Is Your Digital Life. Facebook's failure to review privacy policies or act on red flags amounted to a failure, they concluded, to adequately monitor third-party apps. While companies can generally rely on the good faith performance of contracts, like the terms that all app developers had to agree to, the court in this case raised the bar to kind of trust but verify, where you know if there's a risk of bad actors who will not adhere to those terms, you need to investigate. The Court of Appeal specifically said that at paragraph 117. Facebook is entitled to rely on the good faith performance of contracts, but only to a point. As discussed above, Mark Zuckerberg admitted that it would be difficult to guarantee that there were no bad actors using its platform. It is incongruent to expect a bad actor to carry out a contract in good faith. Facebook, therefore, should have taken further measures to monitor third-party contractual compliance. In particular, the court noted that there were a number of red flags with this particular app developer that should have been pursued more promptly and perhaps with greater consequences to the developer. This does change the analysis a bit. My take, which I think aligns more closely with some of Facebook's argument, are that once somebody has consented to their information being disclosed to a third party like an app developer, that app developer is the custodian of your data, and they are now 100% responsible for securing it and living up to their legal obligations related to that data. The party that disclosed it with consent ceases to be responsible for it in the hands of the app developer. And I think what the Court of Appeal is getting at is that in a case like this, Facebook can't be sure of the bona fides of the developer. And if that's the case, then Facebook continues to have some responsibility for the data. And since the court concluded Facebook had reason to know that the people behind this particular app were perhaps and maybe likely bad actors, permitting them to continue on the platform was inadequately safeguarding users' data. So the issue wasn't really the data once it was in the hands of the app developer, it was safeguarding to prevent it from getting into the hands of a bad guy to begin with. So for me, the main takeaways from this decision are that consent and expectations of privacy seem to be fully objective without regard to the individual at issue or the population we're talking about. I'm not sure I fully agree with this. But the Court of Appeal is also clear, very clear, about something that I've agreed with for some time, and that's privacy policies are not really where you get knowledgeable, informed consent. We know that people don't read them, and courts are starting to understand this. You need just-in-time consent clearly articulated to the individual, And I would still say tailored to the particular audience with whom you're dealing. And finally, trust but verify. You can rely on the good faith of third parties to live up to their obligations under an agreement, unless you can't. If there's evidence to suggest they're bad actors, you may not be able to rely on that. So you need to watch out for red flags. Trust but verify. It will be interesting to see if Facebook seeks leave to appeal this decision to the Supreme Court of Canada, and it will also be very interesting to see what remedies the OPC and Facebook can agree to. And if they can't agree, it'll be really interesting to see what remedies the Federal Court of Appeal imposes. And that, in Canada, will be absolutely precedent-setting. I hope this has been interesting and useful. I try to put out a new video every few weeks or so, so if you're interested in this sort of content, please click the like and subscribe buttons. Also, leave a comment if you have any questions or if you have any suggestions for other topics to cover. And of course, feel free to share this with anyone who you think may be interested in hearing about Canadian tech and privacy law. Thanks for tuning in.